Hi, I am here to talk to you about legal considerations for peptides in a medical practice, advertising, delegation, consents, and insurance. So I gave this presentation last week on March 20th at the Los Angeles Multi-Specialty Cosmetic Academy, and I wanted to record it separately because it was a little rushed. I will say that I was the last of three other attorneys speaking on legal issues of peptides. So I'm not going to go into what they went into on their presentations. Maybe I will record that someday, a part A to this series, and this is part B. But I'm just going to give my presentation because I think a lot of people would have been interested. There were two tracks, the medical track and a business track. And so for those who missed the business track where I was speaking, I'm providing it now. So there's a QR code that you can scan to download the slides. They were created to provide a lot of information for people, and there's also some slides where you may want to copy and paste the content because it's very useful for your practice. And so without further ado, let's see. Okay. My disclaimer is that my presentation does not constitute legal advice. It's for informational purposes only. It's not based on the opinions of the law firms or my clients. And I am outside general counsel to the lovely Dr. Kian Karimi, and I will not be talking about anything related to him or any other clients except for any examples I give are for illustrative purposes only and do not reflect anything identifiable. And we also created this presentation FYI to help practitioners learn about peptide legal issues, and so we really wanted to create something that was helpful. And I have no other relevant financial interests to disclose, and I also have no perceived conflicts. So next. Okay. As I said, I'm a licensed California attorney since 2009. I'm partner of Alliant. It's an international law firm of counsel to Elliott Legal, which was one of the sponsors and exhibitors, and also of Counsel Marino Yebri, which is a litigation firm. And these are some other companies that I'm affiliated with. Some relevant publications that I've written that may be helpful to your medical practice are here. And these are just prior speaking engagements that are relevant to the business and the practice. Okay, so here's just an overview. As I said, legal considerations of peptides in the practice. And first, I'll talk about advertising issues related to FDA and FTC compliance, deceptive claims and risks and enforcement, and then delegation and supervision issues. We'll talk about what's the scope of practice in California and how medical spas and practices can comply and what happens if you don't. And then I'll talk about patient-informed consents, legal requirements and how to draft them, and some sample informed consents. And then finally, we'll talk about insurance, which is, something we all should have. So we'll talk about reviewing it, documentation, and internal policies and controls. So first, advertising. It's essential to your practice. You're going to want to advertise your practice that you have peptides, but there are some risks in using the word peptide and talking about injectable peptides. So just also taking a step back, the prior speakers were talking about the legal issues of typically it's injectable peptides, but also there could be other peptides that are oral or skincare products and the risks of using those type of peptides in the practice. So when you are advertising, you need to make sure that your statements are true and that they're validated. If you make false and deceptive claims, the FTC, which is the Federal Trade Commission, they can come after you, and same thing with the FDA, the Federal Drug Administration. So you need to vet them. So like if you have a rep from a peptide company and they are telling you that, this cures obesity or this will cause, create additional regeneration, you need to vet whether or not that's true and not just regurgitate those statements. And then using absolute terms are problematic. And also, if you work with influencers, you sort of have vicarious liability, which is when you could be liable for the torts of others. And so it's, usually with employees, but It's the same kind of concept with hiring another party. You can be liable for their misstatements. You need to make sure that their contracts indemnify you if they do not follow the instructions that you provide for them, and ask them not to make any false claims. Same thing with fake reviews or paid testimonials. I don't recommend those, but make sure you're not saying that this is a cure or that this is better than Ozempic, and I'll go into more specifics of that in a second. And then I'm going to talk about enforcement trends. Okay, so I created this slide based on a client had contacted me. She wanted to advertise her peptide therapies on a billboard. And I was like, well, there's probably a reason why we don't see drugs advertised on billboards or those types of claims, because there's not enough room for disclosures. So really not a good idea. You can say things like weight management consultations or obesity treatment plans, prescribe therapy, injectable medication, or provide educational info. Some risky language would be in the yellow. And then what you really want to stay away from is saying, unfortunately, injectable weight loss medications, specific drug classes, or outcome guarantees. No guarantees in medicine. Unfortunately, you should not be making any kind of guarantees, and you should be training your staff about such as well. And any claim implying efficacy can be considered misleading. So I actually was asked to review a website of another client, and I just looked at one page and I'm like, red flag, red flag. You can't say this. You can't make disease claims. You can't do this. And so I just told her, before I review the rest of your website, you need to fix the rest of the pages based on this one page. And so that's what she did. I should let you know that medical boards do look at websites, and they will actually quote language in the complaints. Instead, you should have a disclaimer on your website. So this is the language that you can copy and paste. This is something my colleague and I prepared for a client to put on her website. So just download and copy and paste, because you do not want to get this letter. So this was a letter sent to Hims and Hers. I've recreated it. It was only electronic. This is basically what it would look like, that you would receive something like this, a warning letter. They had the issue that the website said weekly injectable GLP-1 with the same active ingredients as Wegovy. Can't say that. Clinically proven ingredients. Nope, can't say that either, because they're providing the compounded versions of these drugs. So it's not clinically proven unless it's a drug. So that's been vetted by the FDA. And so, you know, they said in this that your claims concerning compounded semaglutide products are false and misleading. They are not compounded drug products, are not FDA approved. Your claims imply that your products are the same as FDA product when they are not. As a result, these claims are false and misleading and misbranded. So you are responsible for investigating and determining the cause of any violations, preventing their reoccurrence, and it is your responsibility to comply with the law, and you need to take immediate action by ceasing and desisting from using this language. And if you don't, then you can be subject to seizure and injunction. And so that's true. You need to, if you get a letter like this, you may need to stop sales of a product. You may have penalties, orders requiring consumer refunds, and also besides this, you may get a class action lawsuit. So these plaintiffs' lawyers are looking to go after companies that are making false and misleading statements to consumers. So don't do it. Go for the green language. Okay, so besides that letter from the FDA and FTC, I'm going to talk about another lawsuit in a second that you can get. We'll get to that, but first I'm going to talk about delegation and supervision. And so this means that in California, you need a physician to supervise the practice. A physician needs to be involved, and even more so based on a new bill, which I'm not going into, but if the doctor is, or if your practice is prescribing peptides, you need a doctor that is involved by supervising and delegating properly, or collaborating with the mid-level providers. So that means that standardized procedures must be in place. These are internal documents between the doctor and the nurse. And then with a physician assistant, it would be a practice agreement. And then also a good faith exam needs to be conducted. That means that you need to assess whether this patient is even eligible. And that can only be provided by a doctor, a nurse, or PA, an NP or a PA, not an RN. So you need to be careful because otherwise you could be subject to this lawsuit, which I'll go into in a second, or you can get a medical board complaint, which discusses how, if you fail to comply with the supervision requirements, it can lead to aiding and abetting the unlicensed practice of medicine. Even a doctor can get in trouble for that, and certainly lay people if you have an MSO, management services organization involved. And so one thing that a doctor can do with peptides is they can look for the certificate of analysis to verify the purity of a compound and then determine if it's properly prescribed for that patient. So I'm going to go further into this. So these are some example complaints that you can get. There's the nursing board complaint that I'm going to go over first. These are just some quotes from an actual complaint, and these are just unbelievable. So the nurse said the doctor hardly ever comes to the med spa. They were interviewed by the investigator, and that was a failure of their attorney to properly coach them, in my opinion, because they should have responded, these are the dates the doctor came to the med spa, or I don't recall, because that does not sound good. The doctor is hardly ever there. Sometimes it's about the optics of the situation. So your lawyer can prepare all these perfect documents or review them. I don't prepare standardized procedures, but I do look at them to see if they're in compliance. And then people who work there or these patients don't know that there's a doctor involved. And so with this situation, a nurse who worked there, another nurse who was an employee, you could have a disgruntled employee who's interviewed, said the doctor never reviewed any charts or provided any feedback. And the document that they had wasn't even real standardized procedures, so it didn't comply, which I'll go over in a second. So you really don't want to get into a situation like that with peptides, because you need to have specific protocol on whether or not patients are eligible, how to inject, what happens if there's an emergency. So I'll go into that in a second. But there's also this medical board complaint to a doctor where it said the doctor had no responsibilities in the day-to-day operations of the practice and didn't see any of the practice's patients. It's not necessarily going to get the doctor in trouble to not see any practice patients. He didn't end up getting in trouble for that, but it just doesn't look good. So if the doctor is consulting on things, that would be better. And in this situation, the doctor was basically, it was like a de facto, it wasn't real ownership. So they were just trying to build their case against the doctor. And they also mentioned that the practice had no input about the website, had no input about the doctor. There was no presence of the doctor, and the doctor had no input on what goes on the website. So that's not good either. The doctor should have been reviewing the website and like providing a stamp of approval, whether it's an email, yes, this looks good. And the doctor wasn't. And then, I have these clients where they're just beautiful nurses and PAs. They all look like models. And then their websites have these photos of them. And I'm like, where's the doctor? Can you please Photoshop the doctor in there? I don't care if the doctor isn't camera friendly, make him camera friendly, to provide some sort of optics that he's actually involved, because we have all these perfect agreements that I worked on for you. And then if a patient could have a complication and the patient doesn't think there's a doctor, even staff there, I've heard situations where the staff is like, there is no doctor, and it's like, yes, there is. There's a doctor. So the staff just didn't know about the doctor because the doctor hardly ever comes to the med spa. So please be careful of that, even with peptides and minimally invasive procedures in a med spa. It's still a medical practice in California. As I was saying, these are the requirements of the standardized procedures. And as you can see, number 5 I highlighted because the protocol and scope of supervision of each procedure must be specified. So I've been asked, does each peptide have to have its own protocol? And I'm like, well, they're different, right? Like if one's helping with weight loss, there's different risks to that patient and different protocol than if they are trying to build muscle or have regeneration. So I would say, yes, they need to be different based on that. And I know it's annoying, but a lot of it is like save as for compounded semaglutide, and then save that document, and then save as compounded Tirzepatide, and then revise. Like that's how you could do it. And so just make sure you have different documents because they could be viewed. So this is an example of why this is relevant. So this is a lawsuit by Eli Lilly against Mochi Health, which is the telehealth company, and Eli Lilly complained about many things of this telehealth company, but they were essentially saying that the management company is running the show, and that this person who's really not a doctor is making a lot of medical decisions when they should have only been making business decisions. And so that's why I'm telling you that the delegation and supervision is important, because in this complaint, I just highlighted a couple of things like Mochi Health experts exerted undue control and influence over the medical practice. I think there was like changes on a mass level to all the patients in terms of their dosage or sourcing. And so how can that be medically based when it's just, based on business, like what's cheaper for the business in terms of costs and provides more revenue. And then they said that the California prohibits unlicensed individuals from practicing medicine. So these people are making, like I said, medical decisions. They were altering dosage for business purposes, and then they weren't providing good faith examinations. And like I said, those cannot be provided by an RN. It has to be provided by an NP or a PA or a physician in California. So again, failure to comply can lead to the aiding and abetting of unlicensed practice of medicine. You do not want to get one of these complaints. Okay, so now we're going to talk about patient-informed consents. And this is a document that goes between the patient and the practice. And in general, it needs to describe the peptide being used, how it's used and administered, whether it's FDA approved or off-label or compounded, and what patients may expect during and after treatment. And you need to disclose the risks and benefits, and if there's any type of failure, contraindications, monitoring requirements, and then present alternatives if there are any, which there usually are, because a lot of clients usually have nothing on there, and I'm like, come on, that they could get, they could go to just a nutritionist or exercise, and that would be an alternative. It may not work as fast, but may not have been working for the patient, but those are alternatives. And then include required disclosures. For example, the FDA website has a lot of them for various procedures, devices, drugs, supplements. So they compiled complaints, and so you should have that in there. It should be comprehensive, because it'd be better for a patient to be informed and then proceed than not be informed and then proceed, and then you have a claim of lack of informed consent. And so here's just an example of an informed consent that a client sent to me. I flagged this and I wanted to bring it up because she said, can you review my Tirzepatide informed consent? And I said to her, okay, why does it say client intake and liability waiver? So as you can see, lawyers, we do these comments in the margin of the document. And so I had to basically inform her about what those are versus what an informed consent is. So the client intake is a questionnaire. That's what the patient would fill out. How much water are you drinking? What prior diseases do you have? What medications are you on? That is what a intake is, and that's not an informed consent. So that's a separate document. And so I'm just focusing on informed consents, but I wanted you to know that, clients have been misinformed about these two types of documents. And then she had liability waiver. We're not going to call a document that's an informed consent a liability waiver in California, because it's likely not to be valid. You can't waive liability for a medical procedure prior to getting the procedure. And so if there was really a harm and the patient was able to get an attorney involved, the attorney would know that would not hold up in court, and it'd probably go against you in court. But that being said, some clients do like to have, and like I said, I represent a lot of clients I have with different practices, so I'm not speaking about any particular client, but some of them have said to me, well, if we put this in there, the liability waiver language, which is on the next page, then maybe the patient will, not go after us and we'll use it to negotiate. And that's true. If the patient doesn't find an attorney, which actually is more difficult in California because we have caps on damages, less med mal attorneys get involved because they want to see six figures. And if this, minor peptide mishap occurs or complication, it's maybe not enough to involve an attorney, because they typically want to see disfigurement or death, something serious. So That's why maybe you might have liability waiver language in the consent. Anyway, so this is just how we work together. She had prepared this, was mostly pretty good, but you see I made some comments and corrections that were pretty important and some distinctions. So just want you to know that you should have an attorney review. Because if she had sent me one of these, I would have told her, no, don't use those because these are only a page long. I found these online, and if they have the name of the practice on there, like I said, I just found these online. I did not, no one sent these to me that I know of. I mean, no one sent them to me. So they're not good enough. They're only one page because you should really be having pages and pages of disclosures, which I'm going to show you in a second. Here's just an exercise that I went through with ChatGPT because I know that ChatGPT and other AI is being used to create various legal documents, but unfortunately, it's really not there yet with creating a lot of legal documents. It might be helpful for a paragraph or, understanding a sentence or fixing some section, but an entire document, I haven't seen one that it's turned out that's been, ready to go. Maybe a letter. Hey, can you respond to this letter? I've seen it do a pretty good job with that, but not a contract that I would draft, and you'll see in a second why. So basically, these are two different consents. The one on the left is 400 words, and the one on the right is 600, and they were just from two different ChatGPT accounts. So one is on the left is from somebody who has a premium account, who's not an attorney or in the medical field. She's just got, advanced degree and works in business. And then the one on the right is from a lawyer, me, and I have a premium account. And for some reason, the same inquiry, create a patient-informed consent for peptides in California, turned out 50% longer document, 12 sections versus 7. So either way, 600 words is not enough because the one that I previously prepared for compounded semaglutide is 2,600 words. So that's a lot longer and it has a lot more protections. So, in mine, before ChatGPT was created, we go over the background, the possible benefits, why it was recommended, a patient attestation about not having conditions. Here's some, I did go back and forth on this form, so there's some comments in there. So, here's some things where I'm like, confirm is true. If it's true that you don't carry, insurance, you should put that in there. The cancellation policy, you should have a cancellation policy somewhere so you don't get abused by patients who cancel last minute. Maybe you don't have to enforce it with them, but you might want to put that in there. And then here's that liability waiver. This particular client had wanted it. So, names of providers. It says I confirm that, I release the practice from liability related to this medication. So it's, again, not going to hold up, but this person had wanted it. So that's, I had to CYA and explain why that would not hold up in writing to her. Anyway, consent, again, should have all the possible side effects, risks of cancers, understanding drug interactions, FDA disclosures, potential risks of doing nothing, alternative treatments, unknown or unforeseen risks, patient responsibility, medical history, directions for use. Again, this is just some of the pages of this behemoth document, and I wanted to just point out that, yours should be robust. Okay, moving on. Wow, the presentation's already at 23 minutes. Yeah, I was not supposed to speak for this long, but I feel much more relaxed giving it on, in the comfort of my office. And so, and not rushed. And I knew that my speakers before me, they wanted to speak for 30 minutes and I did not have so much time for them. So anyway, almost done, hanging in for the last leg. Insurance, so risk management. So most practices know that they need to have malpractice insurance in California, or they should have it. It's not required in California, but it's recommended because otherwise the plaintiffs will go after your personal assets. So, which they could do it anyway, but it helps to have insurance involved to help protect you. And you need to check though that if you're offering peptides that that they're covered. So anytime you have like when you procure your insurance policy in the beginning, you should have them review all your treatments and services, and then anytime you add on new services, you need to email your broker and make sure it's covered. Anytime you have a new provider is added on, but you need to verify it specifically for peptide therapy. And with insurance, you need to document everything that occurs because you will need it if there is a claim. And if you're using peptides, you want to talk about the medical necessity of it for the patient, specific peptide use, source, and the patient response. And then again, these operational internal policies and controls. So tracking where the drug was sourced, any interactions, and you just want to show that you have compliance. So when I'm looking at insurance policies, again, who is insured? I'm going to make sure everybody's insured. What is covered? Make sure the broker sees the entire list of services. Anything new added needs to be updated, and check the policy for any endorsements, declarations, and exclusions to make sure that nothing is omitted. How much is coverage for? So you want to make sure it's sufficient. That's something that independently research based on the size, services, and location of the practice. Where all the locations. I mean, I once had a client who was insured for Arizona because he was living in Arizona and the practice was in California. It's like, I'm glad you figured that out before you had a patient complaint. And then also just going back to the what's covered, you want to make sure that you have coverage for regulatory investigations. It's not just if a patient sues, like I was talking about earlier, if you have a medical board complaint and you need coverage, to the insurance company to appoint defense counsel and assume the defense. That will save you thousands in legal fees if you have a policy that pays for that. So make sure to have coverage for that and it's sufficient. And then, people just forget it's not the only coverage. Maybe if you have a retail place, it's not telehealth, you would want CGL or property insurance, your renter's insurance, and that, if you have employees, you need to have workers' comp. That's required in California. And then, if you have, if you're advertising peptides or you have a website, you want to look into cyber liability, HIPAA and media liability policies, which would be covered, could be covered under the malpractice or CGL. Sometimes clients ask me if it's better to bundle the policies or not bundle, and the answer is that it depends because you need to really get 3 quotes from 3 different brokers and compare them and make sure that you're comparing apples to apples, because sometimes the policy would be less because it's not covering everything. So definitely look into that. And so finally, I'm almost done. Just key takeaways again: advertising, look at your website, make sure your statements are true and non misleading, no guarantees. And delegation, make sure you have a physician involved who's properly supervising and delegating or collaborating with the practice. You have these informed consents that are robust, reviewed, and worked on with an attorney is what I recommend, and that the insurance policy is reviewed. Usually the clients don't want to review the insurance policy or they're too busy, so I recommend an attorney, and I used to co-counsel with an insurance coverage attorney specifically. So if you want to contact me for a free peptide checklist, by all means do. And here's my contact information, and I'm not sure if you can scan the QR code because my video's in the way, but just email me. And I hope you enjoyed, and good luck with the peptides. I actually have some sitting in my refrigerator. I've never used them because long story, but anyway, just was looking for the oral ones, and it was miscommunicated. So I now have vials of stuff that hasn't been touched, but yes, nothing any client of mine touched or doctor of mine or friend. So I want to make sure that people are safe when using these, and that's why I put out this information. Safety, patient safety should be your #1 priority. And but contact me if you need help.